Hello everybody, I am M.M.Naikwadi, advocate from Dharwad, Karnataka. Today I am going to deliver a brief lecture on the stages of the suit. Please like and subscribe my videos so that you can get such videos in future. So first of all, a plaint with enclosures is filed before the court and the court registers it as a in FR number, that is filing register number, is given, and thereafter regular number is given. Sometimes filing register number is given for maintainability. For example, if any notice is exemption application is filed, for example, under section 80 subsection 2, exemption of notice is filed, no permit number is given, and only after first orders are passed, then only permit number is given. Likewise, usually the after registration of the suit, the matter comes for first orders. In case of interim applications, that is temporary injunctions, the plaintiff's counsel has to make a brief hearing, and in his discretion, if the court pass ad interim injunction, the plaintiff has to comply as per order 39 rule 3. And there while passing the order for TI, the court also issues summons, notice on TI, and the emergent notice on interim application, etc. Thereafter, the plaintiff has to comply the same, and the summons are issued to the defendant. The defendant, he will receive the summons and appear through counsel, and thereafter the defendant may file WS, written statement, he has to file the written statement within 90 days. Then once if the written statement is filed, then thereafter the court frames the issues, and after the framing of the issues, as per section 89 of the CPC, one stage, that is mediation, is fixed, and the both parties were told to be present before the court. The court asks with regard to the compromise, if any of the parties are interested in compromise, etc., or settlement, etc. Then the court proceeds to next stage is list of document and list of witnesses. In this, at this juncture, the plaintiff can or the defendant can file the documents only with the list, or the list of witnesses only list of witnesses. But once if this stage is over, then the court fixes next stage, that is evidence, and as per order 18 rule 1, the plaintiff has to begin this case by among the plaintiffs, one of the plaintiff has to lead the evidence as PW1, and he has to mark the documents as exhibit P1 series, and thereafter the counsel for the plaintiff, the counsel for the defendant will cross-examine him, and if necessity, the plaintiff has to lead the evidence of other witnesses as PW2, PW3, etc. For example, in case of will, the attesting witness or the scribe has to be examined. Likewise, in case of suit for specific performance, the witnesses or the scribe has to be examined. Likewise, in case of any other suits, depend upon the necessity, the witnesses should be examined, and those witnesses being cross-examined by the counsel for the defendant. Then, after the closure of the evidence of the plaintiff, the case is posted for evidence of the defendant. Among the defendant, any one of the defendant can lead the evidence on behalf of self or other defendant, and he has to mark those documents as exhibit D series, and his witness deposition is termed as DW1 series, etc. So after his evidence, the counsel for the plaintiff will cross-examine him. Then the Defendant, if necessary, can examine his witnesses as DW2, DW3. Even from the witnesses also, documents can be marked, and depend upon the necessity, only the defendant can examine the witness, etc. Then the plaintiff counsel cross-examine them. After those completion of the evidence of the defendant, the court will fix the next stage is argument, and the plaintiff counsel has to begin with the argument. Thereafter the defendant counsel reply the same, and thereafter the plaintiff will reply the same, etc. Then the case is posted for judgment, and after judgment is made, within short time the decree is passed by the court.